Good afternoon. My name is Martin Grayson. I'm the author of The View from the First Chair, which is a book about how to litigate, how to think like a lawyer. In this segment, I'd like to talk about contracts. Now, you might think contracts are transactional work and so not related to litigation. But of course, a great deal of litigation arises out of contracts. And in my opinion, litigators make good transactional attorneys because they are attuned to litigation and where litigation might arise in any contract or from the transactions underlying the contract itself. The thing to remember about contracts is all contracts can be divided into two parts. First is the deal. Second, potential for litigation, the indemnities, the liabilities. The deal is generally going to be in the hands of the corporate people, depending on whether you're general counsel or outside counsel, your relationship to the contract, you'll have more or less input into the deal itself. You might, as I have in some cases, end up negotiating deals for your clients. In many cases, you'll simply be brought in afterwards to look at the contract and decide whether it's appropriately phrased for your client and their positions. In either event, though, the thing for you to be most aware of and to pay most careful attention to will be the liabilities sections. Who is responsible for what in any given contract? And here I have a shortcut for you. Clients generally are fixated on the potential problems that might arise in any contract. For example, I had a case once in which a contract was being negotiated for shipment of a food product from the United States to the Far East. My client had myriad concerns about what might happen to the product, the various contamination that might occur, what would happen during transit, the handling, thousands and thousands, literally, of imaginary problems that this manager was conceiving and trying to get me to detail every single one of those points in the contract itself. I pointed out to him that there were really only three circumstances that he had to be concerned with, because there were only three possible outturns for that product. You can guess what those are. The product can either arrive in perfect, satisfactory condition, in which case there's no problem, no indemnities, no liabilities, nobody has a concern. Second, the product can arrive entirely destroyed or contaminated or unusable. And third, the product, as you can guess, can be partially contaminated or destroyed. If you phrase the contract and the potential liabilities in those terms, you can easily see that in those three circumstances, two really, because we only have two bad outturns, in those two circumstances, you can set in the contract who is going to be responsible for which of those outturns. In the first case, it's not too difficult to imagine that there was something wrong with the manufacture or the initial packaging of the product that made it go bad in transit. I'm assuming now, of course, that a ship didn't sink or a container didn't drop off a crane and fall 300 feet onto the pier. Absent that sort of casualty, the only thing that could go wrong with all of the product is it was set up wrong at the beginning. Your contract can make provision for that. The responsibility for completely bad outturn would fall on the shipper/manufacturer. On the other hand, when product is only partially destroyed or contaminated or unusable, that might be the fault of the carrier of the goods or somehow the handling of the goods, either when it was sent out or when it was received. Again, your contract can make provision for who is going to be liable and to what extent for that circumstance. So the thousands of potential problems that you face in a contract and the liability and responsibility for those problems can really be brought down to two different circumstances, and your contract can deal very readily with who will be responsible for those two outcomes.